Welcome everybody, and thank you very much for taking the time to attend the session this afternoon about electronic conveyancing. For those of you I have not had the pleasure of meeting, my name is Jean Bellani, and I'm the Director of Registrations at Landgate and also the Delegated Registrar of Titles. Bruce Roberts, Landgate's General Manager Operations, who is the Chair of the Australian Registrars National Electronic Conveyancing Council, or ARNECC as you would know it, is here today with us in the audience to answer any questions you may have about ARNECC. So feel free at the end of the presentation to ask any questions that you may have. I'm going to provide you with a brief introduction to National E-Conveyancing by way of an overview to set the context for the detail. Then I'm going to pass you over to Rachel Offer, Landgate's Legal Counsel, who will present more detail on the items currently out for consultation. So the purpose of today's session is twofold. Firstly, informal early consultation on the proposed electronic conveyancing national law. The introduction of national electronic conveyancing is part of the Council of Australian Governments, or COAG's, Seamless National Economy reforms, for which COAG has set milestone dates which must be met. The introduction of the electronic conveyancing national law is one of those milestones. To meet the milestone, the host jurisdiction, which in this case is New South Wales, must introduce the national law this year. To enable stakeholders to properly consider the national law within the consultation period under the regulatory impact statement, ARNECC provided an early release of the national law in August last year and is providing further detail of the national law in this session today. Secondly, this session will promote and facilitate formal consultation on the key legal framework documents. That's namely the model operating requirements and the model participation rules. National electronic conveyancing is part of the Council of Australian Government's reform agenda. It's about creating a national partnership to deliver a seamless national economy. This national partnership will be delivered through an online business platform or electronic lodgement network. The platform is to be known as PEXA, or Property Exchange Australia. National E-Conveyancing Development Limited, or some of you may know it as NECDL, is building the PEXA platform. NECDL is an unlisted public company, the shareholders of which are the states of New South Wales, Queensland, Victoria, Western Australia, and a number of banking institutions. It's anticipated that the first release of PEXA will be available in at least one jurisdiction, either Victoria or New South Wales, by mid-2013. Further details about PEXA is available from the website, detailed on the next slide. There will be a web-based hub for the electronic preparation and lodgement of land registry documents. PEXA will not directly alter or update data held by a land registry, nor create a national torrens register. It's a gateway or channel for documents presented to be lodged with the relevant land registry. Land registries will remain responsible for the examination and ultimate registration of documents. Indicative timeframes for implementation of PEXA at a national level is that the first release, which will contain discharges and mortgage documents only, is mid-2013. The second release, which is transfers, discharges, mortgages, caveats and withdrawal of caveats, will be 2014. In Western Australia, Release 1 is scheduled to be implemented around November 2013. PEXA will provide an electronic financial settlement service as part of its platform. The financial settlement component is separate from the interaction with the Land Registry. The Land Registry will not have any involvement in or control over or regulation of the financial settlement component that occurs within PEXA. PEXA will only be able to be used by registered subscribers, such as lawyers, conveyancers and lenders. It is not intended that PEXA will be available for use by members of the general public. They will need to be represented by a subscriber to access PEXA. Further information is available on the web if you go to www.nationaleconveyancing.com.au. The Australian Registrars National E-Conveyancing Council, ARNECC, comprises registrars of the equivalent statutory officers in each state and territory. The Council is responsible for the regulation of national e-conveyancing to the extent that it enables or relates to the lodgement of documents with the Land Registry and the relationship between the registrar and an electronic lodgement network operator, that is, the provider and operator of the electronic lodgement network. The ARNECC Charter is available on the ARNECC website, the details of which are on the slide there, so it's www.arnecc.gov.au. So where are we at in progressing the development of the regulatory framework? As you can see, we can tick off a number of items. The Intergovernmental Agreement, or the IGA, has been agreed by all states and territories except the ACT. The purpose of the IGA is to establish a framework to facilitate the implementation and ongoing management of the regulatory framework for national electronic conveyancing. All states have signed the IGA, with the exception of South Australia, which is in the process of obtaining the necessary approvals. The ACT is not at this stage participating in national electronic conveyancing, as the majority of the land in the ACT is Crown land and is not within the scope of electronic conveyancing. The IGA is structured so that national electronic conveyancing can still proceed to implementation, even if some of the states and territories have not yet signed the documentation. The second item we can tick off is the proposed electronic conveyancing national law, which has been approved by ARNECC for consultation. The Regulation Impact Statement, or RIS, for the national law has been approved by the Commonwealth Regulator. Approvals from all states and territories are being sought for the release of the Regulatory Impact Statement. The Draft Model Operating Requirements, or MOR, have been approved by ARNECC, and the Draft Model Participation Rules have also been approved by ARNECC. So there has certainly been some progress. Now on to the regulatory framework. As a high-level overview depicted on the slide, we will have the Electronic Conveyancing National Law. At the top, sitting under that, there will be the Model Operating Requirements and the Model Participation Rules, as you can see in the slide. Under those will be the two relevant agreements. The Operating Agreement, which is the contract between the registrar and the electronic lodgement network operator, and the Participation Agreement, which is the contract between the network operator and the subscriber. So what are our next steps and actions? Consultation papers, overheads and feedback template are available on the ARNECC website under the Resources tab. Feedback on the MOR and MPR are due by the 25th of May 2012. This feedback date has been extended from the 11th of May. In your handouts, I believe that you have the 1st of June as the date specified on the slide that you have, so please note that that is actually the 25th of May, not the 1st of June. Also, please use the feedback template that has been designed to enable simple collation of comments. So it's really important and encouraged to use that feedback template. Feedback should be emailed to the chair@arnec.gov.au, and all feedback will be public unless requested otherwise. So if you don't wish your submission to be made public and available, please make sure you specify that on your submission, although the preference is to keep it in the public domain. The release of the regulatory impact statement on the national law following government approvals is likely to be around the middle of this year. I will now pass you over to Rachel Offer, Legal Counsel Landgate, who will speak on the 3 proposed key legal framework documents to give you some detail: the Electronic Conveyancing National Law, the Model Participation Rules, and the Model Operating Requirements. They will be done as 3 separate presentations, and we will have a break between the participation rules and the operating requirements so that we don't give you too much information in one go. There will be an opportunity to ask questions at the conclusion of each section of the presentation. Thank you.
Good afternoon, everybody. Thank you for attending. I know this presentation is rather a dry topic, so before I started I did a Google search: jokes on the Torrens system, absolutely nothing. Jokes on conveyancers, absolutely nothing. Jokes on lawyers, about 1 million jokes on lawyers, all of which were too rude to tell you. So I'm afraid you'll just have to persevere with me while I go through the presentation. I will go through the presentation on the national law relatively fast because I think you'll probably be more interested in the participation rules, which is the rules that govern the use of the system by lawyers, conveyancers, banks and other subscribers. Now, as Jean mentioned, the proposed National Electronic Conveyancing Law is to be introduced into New South Wales as the host jurisdiction, hopefully by the 3rd quarter of this year. After that, other jurisdictions like Western Australia will introduce the law in their jurisdiction, either as an application law or as corresponding law. In Western Australia, our government policy is that we introduce corresponding or mirror legislation, which is what we will be doing. The purpose of the national law is to facilitate national electronic conveyancing. It has key provisions related to electronic lodgement, client authorisations, the reliance on digital signatures, electronic lodgement networks and operators of the network, operating requirements and participation rules. It has appeal provisions relating to compliance examination and an interpretation section, and I'll speak in more detail on all of those. In relation to electronic lodgement, it was thought that the Electronic Transaction Act in the jurisdictions was not sufficient to provide confidence to parties to conveyancing transactions that the electronic conveyancing transactions would be on the same foot as paper documents that were registered. In addition, it was thought we needed a common national legal framework for electronic conveyancing so that across Australia everybody's operating on the same basis. So the national law provides that documents can be lodged electronically. It empowers the registrar in each jurisdiction to receive and deal with those documents lodged electronically if they're in the appropriate form and if they're lodged through an approved operator. It provides that electronic documents have the same status as the equivalent paper documents, and it enables that documents signed by using a digital certificate by a subscriber have the same effect as if they were executed in paper using a wet signature by the subscriber's client. One of the key empowering provisions in the national law is the provision for client authorisations. In electronic conveyancing, vendors and purchasers don't wet sign paper documents. They authorise their representative, their lawyer or their conveyancer, to affix a digital certificate to a document to sign it on their behalf. So we needed to provide for an authority for the client to give to the conveyancer authorising the execution of documents by a digital certificate. So that is what the client authorisation agreement does. And I will speak in more detail when I talk about the participation rules about that important client authorisation agreement. It is not a power of attorney, and the national law makes this specific. It was provided in the national law that the client authorisation is not a power of attorney because we didn't want the client authorisation to have to satisfy all the separate laws throughout Australia on powers of attorney. And we didn't want the client authorisation to have to be registered, for example, with the Land Registry before the transaction could come in. So what is the client authorisation? Essentially, it is a standard form that enables a subscriber, which is the conveyancer, to digitally sign electronic documents on behalf of their client, to lodge the documents electronically with the Land Registry, to complete any financial settlement electronically in relation to the transaction, and to do anything else necessary to complete the transaction. Another key component of electronic conveyancing, as I mentioned before, is the use of digital signatures. It's really important that all parties to a transaction are able to rely on the validity of the electronic signature on the document. So the national law provides what's called an attribution rule, and an attribution rule is simply a statement as to when parties will be bound by the affixation of a digital certificate to a document. The attribution rule is in section 12 of the national law, and I'm not going to go through it in detail. I'll leave that delight up to you all. But you will see that it is a fairly strong attribution rule which benefits parties relying on the rule. Effectively, the parties that can rely on the signing of a document electronically are the parties to the transaction, their subscribers, any person claiming through a party or a subscriber, and the registrar once the document is lodged. Section 12 also sets out the circumstances in which you can disclaim the signing of a document by a digital certificate. If you have any questions on that, once you've had an opportunity to read it, we'd be happy to take feedback on the attribution rule. It was developed as part of the legal framework by Clayton Utz, who in 2010 produced a comprehensive recommended legal framework report, and we have based the attribution rule on their recommendations. The legal framework report is, if anyone is interested, is available at www.nex.gov.au. And it was developed after significant stakeholder consultation across Australia. So that brings us to the actual network and the operator of the network. As Jean said, electronic conveyancing is a hub-based web environment. So you need an operator to run that hub so documents can be lodged through the hub. The national law provides that a network can be established. It can either be provided by an approved operator or by the registrar, him or herself, in the jurisdiction. And it's simply a system that enables the online preparation and then subsequent lodgement of documents in an electronic form. The preparation and the lodgement is facilitated through something called an electronic workspace, which is like a shared space that parties to the transaction, the solicitor for the vendor, the conveyancer for the purchaser, the incoming bank, the outgoing bank, all enter into and complete the documents or their component of the documents electronically. So the national law has to enable the registrar to approve an operator of the network. It enables the registrar to set conditions on the operator, which are the operator requirements, and to set conditions on users of the system or subscribers. And those conditions are called the participation rules, and I'll be speaking on both of those documents later in the presentation. So to make sure that we have common rules across Australia, the Intergovernmental Agreement provides that the Australian Registrars National Electronic Conveyancing Council, which is a big mouthful, so I might just call it ARNECC from now on, will develop model operating requirements and participation rules. So in the jurisdiction, the registrar has to have regard to those standard national model requirements and rules when determining them for the particular jurisdiction. There's a statutory obligation on an operator of an electronic lodgement network to comply with those operating requirements, and similarly there's a statutory obligation on users or subscribers of the system to comply with the participation rules. The national law also provides powers on the registrar to do compliance examination, and the power is to be able to be exercised to make sure that an operator is complying with the operating requirements or that a subscriber is complying with the participation rules. A compliance examination could be carried out on a random basis or in response to an allegation or a suspected irregularity or complaint. There's no obligation on the registrar to do an examination, and if the registrar conducts the examination in good faith, then the registrar won't be liable to any party for the examination. The manner in which a compliance examination on an operator or on a subscriber will be conducted hasn't yet been determined. It's likely that if the registrar has to do a compliance examination on an operator to make sure they're playing by the rules, that will be coordinated nationally through ARNECC. In relation to subscribers within the jurisdiction, Landgate's currently in preliminary discussions with the industry regulators as to how a compliance examination would be carried out. We anticipate that it would probably be done in conjunction with the industry regulators rather than by the registrar, him or herself. The national law also has a number of appeal provisions. There's an appeal right in an operator if the registrar refuses to approve the person as an operator, or refuses to renew their approval, or suspends or revokes their approval. There are appeal rights in subscribers, lawyers, conveyancers and the banking sector, if the registrar restricts, suspends or terminates their use of the electronic lodgement network, or if the registrar directs the operator to restrict, suspend or terminate their use of the electronic lodgement network. In Western Australia, those appeals will be going to the State Administrative Tribunal. When you have national law, one of the difficulties with ensuring consistent interpretation is that all states have a different interpretation act, so the national law in one jurisdiction can be read differently than in another jurisdiction. So the schema of national law excludes all the state interpretation laws and puts in a schedule of interpretations which will apply nationally. So when you get to the back of the consultation paper on the national law and hit the schedule of interpretations and definitions, that's why it's there, to ensure that there's consistency in interpretation across the jurisdictions. Now, I hope that presentation hasn't put you to sleep. I know it's fairly dry and droll, being a presentation about proposed legislation, but I'm hoping this beautiful picture of a sunrise is going to wake you up before I start talking about the participation rules. And I want you to be awake because the participation rules is the key document as far as you are all concerned. Before we go on, are there any questions on the proposed national law? I was tempted to wait 2 seconds and then continue then, but I'm glad there are no questions. But if you have something you want to discuss with me afterwards, please feel free to come and see me. Right, the proposed model participation rules. This is the most important document from your point of view, as I said before. The model participation rules are the rules that will apply to subscribers or users of an electronic lodgement network. They will be in 2 parts. There will be the part set by the registrars, which is the model participation rules, but the operator of the system may well have other rules that it wants users of the system to comply with. So in this section, we're only concerned with those rules set by the registrar. Now, I have already talked about the regulatory framework set up in the national law, so I'm not going to go through this in any detail, other than to note that the participation rules under the national law must be made publicly available, and any changes to the rule must be made publicly available 20 business days before they take effect, unless there's an emergency situation. Now, as I mentioned before, the participation rules, there's a statutory obligation to comply with the participation rules. But before you become a subscriber, you must be able to show that you can comply with the participation rules at the time you apply. The subscriber must also comply while they are a subscriber. And even once you've stopped being a subscriber, there are some participation rules that will continue to bind you as a subscriber. And those are provisions relating to, for example, making sure that you retain the relevant supporting documents for a transaction that occurred while you were a user of the system, protecting information in relation to transactions you undertook while you were a user of the system. If you become aware after you cease being a subscriber that there's been some compromise of a transaction, then you need to let the operator know. And provisions relating to not changing any data in the system. To be a subscriber, there are a number of eligibility requirements you have to meet. The first is you must comply with the laws of the jurisdiction in relation to whether or not you can be a representative. A representative is just somebody who acts on behalf of a client. So if in a jurisdiction you are required to be licensed, to have insurance of a particular type, then you must meet those requirements within the jurisdiction. You must have an ABN. If you're a company, you must comply with the Corporations Act. You must be of good character and reputation, and you must comply with the insurance rules, which I'll speak about shortly. So if the laws of the jurisdiction allow people acting for themselves in a conveyancing transaction to act for themselves, then that person can be a subscriber, but they must still meet the insurance rules. So, for example, if you are a property developer who is acting on transactions on your own behalf, you're buying or you're selling, and you're entitled legally to act for yourself in a transaction, then you can participate as a subscriber in electronic conveyancing, subject to meeting the insurance rules. Now, if you are a lawyer or conveyancer, then your existing professional indemnity and fidelity insurance will be sufficient. We don't expect you to take out additional insurance to cover electronic conveyancing. If you are a financial institution approved by the Australian Prudential Regulation Authority, or a government department or statutory body that's an agent of the Crown, you don't need insurance to be a subscriber. We will accept self-insurance in that case. In all other cases, you must, as a subscriber, maintain professional and fidelity insurance with an approved insurer for at least $1.5 million per claim, and which covers conveyancing transactions. So if you're a lawyer and conveyancer, your usual insurances will be satisfactory. If you're, for example, a property developer acting on your own behalf, then you have to have at least $1.5 million insurance, and your insurance must specifically cover conveyancing transactions. Now, the role of the subscriber. The subscriber can act on their own behalf. So if you're a conveyancer buying your own property or selling your own property, then you can act in that capacity. Or if you're a conveyancer acting for a client, you can act as you do now for a client. For each lodgement or package of electronic documents comes in, there must be a responsible subscriber. So that's really just a nominated lodging party, nominated and agreed in the workspace. Subscribers are under general obligations in the participation rules. Firstly, they have to comply with the laws of the jurisdiction and with the participation rules. They have to make sure that all their users comply with the participation rules. They have to use the standard client authorisation form. They have to verify their client's right to enter into the transaction, which is what you would do now. If you had an attorney coming to you, you would check the power of attorney. If you had an officer of a company coming to you, you'd check the delegation from the company and make sure that that person was entitled to act for the company. You must comply with the verification of identity rules, which I'll speak about shortly. You must retain documents for a minimum of 7 years. You must exercise due care and diligence when conducting transactions. You must provide assistance to the registrar, the electronic lodgement network operator or other subscribers. You must protect sensitive information, ensure the information supplied into the workspace is correct to the best of your knowledge, and you're not allowed to transfer your subscription to the electronic lodgement network. Now, as I said before, the client authorisation is the document by which the client authorises you to act for them in the electronic transaction. The standard form proposed client authorisation is in Schedule 3 to the consultation paper. In addition to the actual client authorisation form, we've prepared a completion guide which explains how the conveyancer completes the client authorisation form. And we've made provision for 3 different situations. We've got the form provides for a specific authority where you're acting on a once-off transaction for a client, a standing authority where your client says, act for me for the next 2 years on this range of property transactions, or a batch authority where your client says, I want you to act for me on all these lots, the subject of deposited plan 1, 2, 3, 4, 5. So it covers a range of different situations that we think conveyancers come across in their day-to-day business. As I noted before, one of the key components of the participation rules is an obligation on the subscriber to do identity verification. The rule is 6.5 in the participation rules, and it says the subscriber must comply with the verification of identity rules. The verification of identity rules are in Schedule 8 to the participation rules. So the question is, who does the subscriber have to identify? And I'm just going to briefly run through it. The subscriber must identify every person appointed to sign for the subscriber using a digital certificate before the person uses the digital certificate. Where the subscriber is a mortgagee or representing a mortgagee, and where a mortgage or a discharge of mortgage is being given, the mortgagor must be identified before the mortgage is signed. Every legal person making up your client must have their identity verified before the client authorisation form is signed. If your client is acting through an attorney or through an authorised company officer, then that attorney or the company officer must have their identity verified. It's a face-to-face schema, so you have to see the person whose identity is being verified, so you can compare the photo in the passport against the person who's presenting in front of you. Original documents must be presented, and we've designed it as a cascading schema so that you must try and satisfy the highest class of documents first. So, for example, the first category is Australian passport plus Australian driver's licence, photo card or proof of age card plus change of name or marriage certificate if necessary. And we anticipate that about 65% of the Australian population will be able to meet that first category of documents. And then it goes down into a cascading regime. If a person doesn't have identity documents, then there's provision for another person who has known them for more than 12 months to say, yes, I know this person, I've known them for more than 12 months, and once their identity is verified, you can rely on a statutory declaration to that effect. The standard provides for the use of agents. So if you can't see your client face-to-face because, for example, they live up in the northwest and it's inconvenient for them to come down to Perth just to have their identity verified, then you can use an agent to do that for you. However, the subscriber always remains liable for the verification of identity. I know in Western Australia we're considering introducing a similar verification of identity standard for paper transactions, and we're proposing using Australia Post as an agent who can conduct identity verification. The discussions with Australia Post haven't yet been finalised, but we're hoping that if the arrangements work for the Western Australian industry, that they'll be extended nationally, and Australia Post will be an agent who will be entitled to do identity verification for subscribers nationally. So that's one way of overcoming the difficulty of not being able to see your client face to face when they are in a remote location. There are some exemptions from the requirement to verify the identity of your client. If you have already done an identity verification and it's not more than 12 months old, you can rely on that. If you're a bank and you've used the anti-money laundering counter-terrorism financing schema to identify your client, then you can rely on that. However, any subscriber who chooses not to use the verification of identity standard will be liable in the event that a fraud is suffered because they've used a lesser standard. Section 7 of the Participation Rule has a number of obligations on subscribers in relation to system security. Because it's an electronic system and usernames and passwords are used to access the system and digital certificates are used to sign on behalf of other people, you need a reliable security framework around the use of the system. And these provisions are designed to make sure that the integrity of the system is retained. So subscribers have to take reasonable steps to protect their electronic systems. They must use a digital certificate to sign documents. They have to verify the identity and integrity of the people they authorise to use their digital certificate. They must make sure that only people who are authorised within their business to sign actually sign. They must make sure that any information provided to any authority is correct. Ensure that only properly trained and authorised people within their business can have access to the system. Make sure that their people are trained in how to use the system. They must follow any security policies issued by the operator of the system. And they must notify the operator if they suspect any transaction's been compromised in any way. And there is also an obligation to provide certifications on instruments in relation to the system, which I'll talk about next. So, because documents are signed electronically, there are a number of certifications that are required to ensure the integrity of the documents. And the first is that the subscriber has actually verified the identity of their client, that they are holding a properly completed client authorisation, that they have retained relevant supporting document, and that to the best of their knowledge, the instruments are correct and comply with any requirements of the registrar. Also, if you are a mortgagee executing or affixing your signature to a counterpart of a mortgage, you must say that you have got the customer, the mortgagor, to execute a paper copy of the mortgage. Section 8 deals with amendment to the participation rules. Effectively, it says that the subscriber has to comply with the participation rules if they are amended. Again, the registrar must consult in good faith on any changes before changing them and publish those amendments before they become effective. There is an exception. In an emergency situation, the registrar can change the participation rules without first publishing them. Section 9 of the rules deals with the restriction, termination and suspension of your right to use the system. Now, the subscriber, if given a direction by the registrar or the operator restricting their use of the system, must comply with that restriction. So, for example, if a subscriber persistently does something inconsistent with the rules in relation to a particular transaction type, the operator might say, we won't take any more transfers from you, you can only lodge discharges of mortgages. For example, I mean, it is difficult to imagine the situations where that may arise, but there may be a situation where the operator and the registrar says, we don't want any more of these types of transactions from this particular subscriber, you're suspended from doing those types of transactions. If you're given a direction to that effect, you have to comply with it. If the registrar gives directions relating to the use of the system, then you must comply with those. Now, the registrar has the power to suspend or terminate subscribers for various reasons, and they are set out in the rules. But, for example, they include things like if a subscriber breaches the rules, if a subscriber is acting fraudulently or negligently, if the subscriber poses a threat to the use of the system, if the subscriber hasn't paid their fees. Now, in a settlement transaction, the lodgement fees would be paid at settlement electronically out of the settlement funds. All other fees, so information search fees and lodgement fees where it's a non-settlement transaction, are going to be paid by direct debit from the subscriber's account. So if you haven't paid your fees to the operator or to the registrar, then your right to use the system can be terminated or suspended. If you fail to produce information when you're asked to provide information on a compliance examination, your right to use the system can be suspended or terminated, or if you fail to comply with a written direction from the operator. Those suspension events are set out in Schedule 7 to the participation rules. Now, as I said before, the national law has a schema which enables the registrar to do a compliance examination if it thinks a subscriber is failing to comply with the participation rules. So in Schedule 4, in addition to the powers in the proposed Act, we've set out a procedure to be followed where the registrar invokes that power. If a subscriber is aware that they're breaching the rules, then they have to advise the operator and they have to remedy that breach within 14 days. You'll be relieved to know this is the last slide. So if you have any questions, get ready. There are a number of prohibitions in the participation rules. So a subscriber can't modify or change data received from the Land Registry. They cannot use or reproduce Land Registry data except for the purpose of the transaction. They have to use the network in accordance with the participation rules, and they cannot disclose any information related to a transaction except for the purposes of that transaction. So that is the participation rules in a nutshell. If you have any questions, please feel free and I'll attempt to answer them. And we have a microphone too, I think. Thanks, Peter.
Hi Rachel, Valerie Haskins. I've got a couple of questions, but some of these are just yes/no answers. Just want to clarify, so we have to ID both buyers and sellers to the transaction?
Yes.
If there's 10 directors in a company, do the 10 directors need to be identified?
Well, usually a company in that case would appoint an authorised officer. So
I think for most of the conveyancers in the room, we deal with companies that might have 3 or 4 directors,
well,
not necessarily lots of them, and depending on who's available.
If the company's rules provide that 3 directors have to sign, for example, yes, then 3 directors will have to be identified.
So we'd need to look at the Constitution to identify who's got the power to sign.
Just as you do now for a paper transaction when you check who's authorised to sign on behalf of this company, it's exactly the same. So if the company's Constitution says 3 directors and the secretary have to sign, then you have to identify the 3 directors and the secretary.
Is the identification requirements in the national law or just in the participation rules?
It's in the participation rules, but the national law empowers the registrar to make participation rules which include provisions relating to verification of identity.
Okay, and my last question, with the discussions that have happened from state to state regarding the operating and participation rules, are you expecting there's going to be a rather varied rules in each state?
That's a good question, Valerie. No, we're anticipating that all the registrars will adopt the model participation rules and the model operating requirements. However, because of different legislative schemas in every jurisdiction, there is a opportunity to make jurisdiction-specific operating rules and jurisdiction-specific participation rules. Only one jurisdiction thinks it might need the ability to make specific operating requirements or participation rules. In Western Australia, we don't think that will be necessary. And Valerie, I'll leave it up to you to work out which jurisdiction that is.
Shane Jacobs Settlements. Just two questions. One is what will happen with overseas clients as far as identification? Will that be the same rules now be adopted? And secondly, is it only Australia Post that will be authorised to identify people other than the conveyancer themselves?
I'll deal with the second question first. No, the verification of identity schema provides that a subscriber can use any agent to verify the identity of their client, but the subscriber would need to come to an arrangement with the agent they used, and I would imagine that the subscriber would want an indemnity from the agent they appointed to do the verification of identity on their behalf. And the reason for that is because the subscriber remains primarily liable even if they use an agent. Australia Post is just one option that the land registries are developing to make it easier for the industry to do verification of identity. As part of the proposed package, Australia Post are providing an indemnity to the subscribers, and the terms of that indemnity are still being considered. So that's their model. They see the indemnity as an incentive for the conveyancing community to use Australia Post. But a subscriber can use anyone they want to do an identity verification. Now that's the second question. In relation to overseas identity verification, in the schema we've got category 5, which says if verification's conducted overseas, a foreign passport needs to be produced, plus a full birth certificate, plus another form of government-issued identity document, plus a change of name or marriage certificate if necessary. And again, an agent could be used to conduct that overseas identity verification, but the subscriber remains primarily liable. Any other questions? Yes, Jim. Before the transaction can happen electronically, both representatives would need to be registered subscribers. So we anticipate that perhaps in the offer and acceptance, that would be the appropriate time to nominate if the conveyancer was a registered subscriber and whether or not it was going to be an electronic transaction. So all transacting parties need to be represented by subscribers who are registered. Any other questions?
I'm Norma from Korean Settlements. Do you have to be registered in WA to do settlements in WA?
You have to comply with the laws of the jurisdiction. So in Western Australia, to act for other parties on conveyancing transactions, you need to be a lawyer or a conveyancer and you need to be licensed and appropriately insured. That remains. And we anticipate that the operator will check when as part of the registration process that the entity applying to be a subscriber does have those qualifications in Western Australia. So you will probably end up, when you open your first workspace or apply to register, you will tick the jurisdictions you're authorised to practice in.
Sorry, can I just get you to go over the overseas clients again, if you don't mind?
Yeah, so we have a standard for the verification of identity for overseas clients where that is happening overseas. And if your client couldn't appear, well, they wouldn't in that case appear before you if you're here in Western Australia, then you will need to use an agent to do that identity verification. We haven't gone through and worked out who would be an appropriate form of agent to do overseas identity verification, but I imagine it will be similar to the consular officials that we use currently for overseas identity verification, that same sort of schema.
What do you mean about the subscriber is still going to be liable? I mean, that's
The
it's a
subscriber,
statement more than anything, I suppose.
the subscriber has to is responsible for verifying the identity of their client. So the subscriber has to do it themselves, or they have to use an agent. If they use an agent, they're still responsible for making sure that that identity verification has been done properly. So if you've used an agent and you don't think they've done a proper job, you still have an obligation to make sure that you're satisfied that the identity verification has been properly done.
Barry Pound, LJ Hooker Settlements. In the event of a fraud, which is the question on everyone's tongue, I think, the situation that we have with our PI insurers now is that they have an understanding of our risk. This system, tell me if it's going to be better, because obviously the risk will be lower. And have you consulted with the industry, the PI industry, to allow them to have an understanding of what's going to happen and what the risk would be?
We do believe this system will reduce the risk of fraud and be equivalent or more secure than the existing paper system, because primarily it's introducing a schema for identity verification, which we haven't got at the moment. In developing the identity verification standard, a lot of work has been done over the years, and that has included consultation with the insurers of industry practitioners. I know in Western Australia we have had some initial discussions with the insurers, with Law Mutual and with the insurer for the conveyancers, and those discussions are continuing. But from a national perspective, the response of the insurers has been the electronic environment will probably be a more secure and safer environment. Clayton Utz also, when they were developing the legal framework, did a comprehensive risk assessment which considered all the risks that can arise and the fraud risks, and their conclusion was that the risk of fraud was not increased in the electronic environment. And if anyone wants to have a look at that work, it's again available on the ARNECC website, www.necs.gov.au, under expert recommendations, and it's the risk assessment document there.
Tristan Cockman from Jackson McDonald. Is there a reason why, when we're talking about verifying the identity of directors of a company, why the subscriber can't just rely on the fact that it's been executed by two people in the company according to an ASIC search? Why do they have to verify the specific identity of the individuals?
Because they're using a digital signature to sign on behalf of the client. So at the moment, the client signs the paper document themselves, and the conveyancer would check that those persons who have signed have the authority from the company to sign by checking the memorandum of the company or the constitution. But in the electronic environment, you're signing for your client, so you have to make sure that you're signing for the party that has the authority to instruct you on the transaction. Yes? The stamping arrangements, the electronic lodgement network operator, it's not envisaged at this stage, will provide a mechanism for you to stamp electronically. So our existing revenue online systems will be used when the documents have been prepared and prior to them being lodged electronically at the Land Registry. The operator will do a check with the State Revenue Office. Has duty been paid on this transaction or not? Or has an irrevocable commitment to pay been made on this, which covers revenue online? If the State Revenue Office flicks back a response, yes, green to go, then the documents will proceed to the next step in the process. So the Land Registry should never receive electronic documents unless the duty has already been paid or been committed to be paid.
I'm Craig Gregson from HFM Legal. I'm over here. Hello.
Oh, thank you.
My boss has asked me to raise two questions about eligibility criteria. If a person has an adverse finding against them, say for a solicitor, for example, under the Legal Practice, Legal Profession Act, are they then ineligible to act for themselves in their own conveyancing matters?
That's a tricky question. Is this one of those, I have a friend who was questions on behalf of your boss? The participation rules provide that the subscriber must be of good character, and I'm just looking for it now. I think if you have been, if there's been any action taken by a professional regulator, say for example you've been struck off, then you would not be entitled to be a subscriber. It will depend on the exact circumstances of the case. Any more questions?
Does this mean that private people will not be able to lodge any documents at all as currently at Landgate?
No, it means that private individuals not using a conveyancer or a lawyer will need to do their transaction in paper. The paper system will continue. The electronic system will be used by qualified practitioners and by the banking sector. And there is no current plans to get rid of the paper system. The paper system will continue. And there's no current plan to mandate the use of the electronic system as well. It's a voluntary system that conveyancers can choose to participate in if they wish to. The proposed operator believes that there will be economic incentives to subscribers to use the system which will advantage it over the paper system, and it's hoping that they will get take up in that way.
I just wanted to add something. Sorry, there was someone else?
No, I just say we just might have one last question from you, and then we'll have a 5-minute break so we can stretch our legs.
I just wanted to expand on the gentleman's question there. So you're saying that the paper system will still be used, but you did mention earlier that if there was a purchase of a property and other parties involved in that transaction were registered, that all subscribers, they would have to all be subscribers?
If you want to do the transaction electronically, then all the parties who are acting in the transaction, so the conveyancer for the vendor, conveyancer for the purchaser, the incoming bank, the outcoming bank, would all have to be subscribers.
Okay.
You can't do it half in paper, half electronic.
Well, from our perspective, I'm representative of a legal firm, so most transactions that we would deal with would be court orders, family court orders and matrimonial settlement, something like that. So the parties to the transaction on, say, transfer of land may not necessarily all be represented by a solicitor. So if there was a bank involved and, say, us as a representative of one party, then the other party signing the transfer of land would also have to be represented to be within the electronic system?
We can't compel people to register and be a subscriber in the electronic system. So if one party is not represented, for example, or if their conveyancer doesn't choose to participate in electronic conveyancing, then that whole transaction will need to be done in the paper medium. Also, relevant to your question, you talked about the nature of the dealings you do. The first release is discharges and mortgages. The second release is multi-party transactions, so transfers, discharges and mortgages, withdrawals and caveats. So if your document type falls outside of that initial scope, it won't be in the first or the second release. Not to say in the future that it will be included. One more and then we must stop. I can feel people becoming restless.
In relation to the coming in for banking institutions first, surely the majority of their transactions also include a transfer.
Yes.
So how
that
are
will
you going to manage that?
It
will be a paper transfer initially.
The implementation by NECTL is first to do standalone discharges and mortgages. So if it involves a settlement, it's not in the first release. And they anticipate that they'll have one bank and one state starting up, and then they'll slowly bring on the other banking institutions in the other states and territories. I hope does that answer your question? Good, thank you. Well, we might now stop for a break. I hope you all haven't decided to retire and pack up and run off to a tropical island. So 5 minutes, if we could start by maybe 10 past. Thank you. There's tea and coffee down the back if you wish to have some. Now,